And watching briefs don't address court. On whose behalf are you addressing me?
I am not just watching briefs. I've got instructions.
Mr. Tefo, please sit down. If you don't sit down, if you address me wasting time again, I request the court orderlies and whoever is responsible in this court to make sure that you are taken out.
I'm not intending to interrupt this court.
Sit down. Sit down, Advocate Mr. Tefo.
I'm here to bring the submission later.
I told you that I've heard that. Why must you say it 100
No, I'm
times?
not here to sit and watch.
You are not going to address me.
I've been given instructions, several instructions by Sifiso Maiwa, the brother of the deceased. I've been given the instructions.
You are disturbing court. Please sit down, or I will order that you be taken out. You are disturbing us.
If you feel like that, Your Worship, you can do that. But you must know that you're depriving the right people who are affected by this.
Yes.
This witness is a witness of the great interest to Sifiso Maiwa, to
Mr.
our parents.
Mr. Tefo, sit down and allow Advocate Baloy to continue with what is of interest in this case, which is what I want to hear. There's a ruling for me to make, and time is of essence. I'm saying sit down and allow Advocate Baloy. This is an interruption, and it is rude, if you ask me. It is a rude interruption, which is unnecessary for our people.
Yoguti-ke abamangalelwa balethe enkantolo ngesikhathi. Shushisu uyaphendula-ke babaloyi ukuthi cha mina angaze ngitshelwe okuthize okumayelana-ke nokuthi abamangalelwa-ke bayahluleka ukuthi balethwe ngesikhathi.
Yes, when we adjourned last, you were to address. And before we go there, the understanding was that I will receive heads from everyone before now, which didn't happen. So I don't know. Did you receive heads?
I have received heads, my lord, except from one council. But council was in chambers yesterday to hand deliver them at about 1600 hours, and apparently he couldn't find anyone to deliver the heads to. But I think
so I don't know. Do people have copies for me? Because nothing was sent to me. I checked very late in the night. I didn't see anything. I checked this morning. I didn't see anything.
Well, we did file ours, my lord.
Yeah, yours I did.
Yes.
I did find. I think.
I think my other friend, my other colleagues can speak for themselves. As I say, I did receive everybody else except from Council for accused number 4, but he was here yesterday to deliver the hard copies.
Abameli bakwazile ukuthi balethe-ke amahethu wabo wokuphikisana ngaphandle-ke komlelo yedwa kanye u-advocate oyedwa. Kanti-ke ujaji uyasho-ke naye ukuthi angitholanga mina ama-heads. Kanti-ke ama-heads okamshushisi ngiwatholile, kodwa-ke angiwatholanga-ke shuthi njengoba umshushisi esho ukuthi abanye bakwazile ukuletha, kodwa-ke omunye nje yedwa nje ongakwazanga ukuthi alethe lama-heads.
My lord, I did send heads to everyone whose address I got. I believe heads were sent to you, but I'm not sure. In any event, I do have a hard copy. With your permission, if I can hand them up.
Something has just been brought to me. Is it something like this?
No. It has heads of argument, members of the electronic media.
Melike we-electronic media uyasho ukuthi hayi cha mina awami ama-heads ngafakile. Mhlambe-ke uma ngabe inkosi enkantolo ingathanda ngiphethe nje ikhophi yakhona la kimina. Manje ujaji uyasho ukuthi hayi khona-ke sengitholile nje manje. Uyasho ukuthi nawami ngiwafakile, nanoma-ke wafake mhlambe ihora emva kwaleso sikhathi sasibekiwe ukuthi sifake lama heads lawa izolo ke ngiwafakile kanti khona ke icopy ayifaka la enkantolo njengengxenye ubufakazi ukubonisa ukuthi ngempela uwalethileke.
Still appearing on behalf of accused number 3. Indeed, I also filed my heads yesterday, and the address that I used there was Mr. Ashley Mzukula, the address that I've been having all along in communication since I became part of this court. So I'm not so sure whether that address is still working or not, but we informed our colleague who's assisting the court that apparently there's a challenge with the address. I don't know whether that address is the one that relates to Ashley Nzukula or it's something else, but nonetheless I did find mine.
Yeah, Ashley Nzukula is not around. In his place we have the secretary that we have.
As it is the court, my lord, but nonetheless I also have a hard copy of the case as such, my friend.
Uyasho ke no advocate Nisi ukuthi hayi nawami ke ama heads ukwazile ukuthi ngiwafaka ngiwathumele la enkantolo kanti ke ngithi mangiwathumela ku Ashley Mzukula angazi noma ke ilona akhilele right ke lelo lokuthumela lawo ma heads ujudge uyasho ukuthi cha u-Ashley akekho kwamanje kanti nginomlekeleli la okuyena ke ongilekelelayo kwamanje.
May it please the court, my lord, I still confirm my appearance on behalf of accused number 4. My lord, I was here yesterday in the afternoon, around about 3:45 in the afternoon. I could not find anyone who was going to receive my heads. I then contacted my colleague, Advocate Banoi, for the state for assistance. Indeed, he has confirmed, my lord, that I did phone him to indicate that I was here in court and there was no one to receive my heads. I had a problem with the network where I'm staying. I couldn't send mine, but I have made all endeavors to email my heads to the email address that was provided. It's rsilebe at Judicia. I don't know whether that email address is working or not. Yes. I've also handed my lord the copy of my heads. Thank you.
Ubaba Khumalo ke okuyena okhulumela umangalelo wesine kuleli cala uyasho ke ukuthi ube khona la enkantolo ngabo 3:45 ethi ke uzofaka wakhe ama heads kanti ke akazange athole umuntu wase ke ufonela uadvocate Baloyi naye ke uadvocate Baloyi wasuyaqinisekisa ukuthi ngempela kunamuntu lapho obezokwazi ukuthi mhlambe athole lawo my heads kanti ke uyasho ukuthi isizathu kube ukuthi ngibe nenkinga ne-network la bengikhona ukwazanga ke ukuthi mhlambe ngenza ke ngaleso sikhathi lokho kufanele ukuthi ngikwenze kodwa ke egcineni ngikwazileke ukuthi ngiwathumeleke ama heads namanje nje ngikwazile ukuthi ngiwafake nje ama heads.
My lord, my apologies suffer if the heads arrived late, my lord. I also used the address for R. Silebe, of which when I verified with the Lordship's registrar this morning, I discovered that it was down, and then I've been provided with a Gmail address of which I had used this morning, and I'm told that the registrar has made the copies available for the court, my lord.
Yeah.
As the court pleases.
Kanti ke uadvocate Mshololo uyaxolisa ke ukuthi ama heads angafiki mhlawumbe ngesikhathi la befanele ukuthi ahanjiswe khona ke sengisho la enkantolo uthi ke mina ke ngithe ngisebenzisa ikheli la elithi R Silebe kanti ke kwatholakala ukuthi ke lelo kheli ke li mayelana ke nalo ophansi nje kanti ke nganikezwa ke i-email ye Gmail ukuthi ngithumele lawo my heads khona namakhophi ke akhona walawo ma-heads ngenze njalo.
I believe then you did have sight, unlike me, you did have sight of the heads from your colleagues.
Yeah, some of them, not all. You know, some we just we received shortly before we resumed this morning. So I will just go through them as after my address.
Okay.
Babalo yasho ukuthi hayi ukuthi ngiwathole wonke ama-heads lawa. Kukhona amanye engiwatholile, khona amanye engawatholanga. Kanti ke ngizozama ke ukuthi emva ukuthi ngikhulumisane nenkantolo ngizame ukuwabheka ke lawo ma-heads.
As a court, please, my lord, before the start of the proceedings, I tried to inquire from my colleagues if each should be allocated a certain amount of time to address the court. We haven't really reached consensus. I don't know if the court would like to allocate perhaps speaking time to each speaker. If in the absence thereof, we'll just carry on. There are 6 of us, and that might take some time if we all have unlimited time to address the court.
Yeah, I think we don't have to lose sight of what has already happened. What has happened is that everyone has addressed without, before the written heads, and you are now to address in the light of what was submitted by your colleagues. And I now have before me, which only happened now, this morning here in court after we started, the written versions of the arguments of each and every one. I believe that after your address, or even before your address, we can check if there are crucial issues that need to be added, because I have these heads. I'm going to go through them. Actually, that is what was agreed the other day, that whatever people cannot slot into the time allocated, they will put it in writing, just as Mr. Rosengarten promised that thing. So I'm not expecting protracted addresses unless someone feels that there's something vital that needs to be added to what was submitted on the day we postponed.
As the court pleases.
Manje ke angokuthi sizoqhubeka ke ngenqubo kube naleyo nto leyo ukuthi ukushushiswa ibuza yona ukuthi ngabe ke isikhathi sobe sanele yini ngoba ngibheka nje ngiyabona ukuthi siba u6 la shuthi ke izazi zomthetho siba u6 manje ke uthi ngiyabuza ukuthi ngabe lokho kuyokwenza ke ukuthi isikhathi sisetshenziswe kahle ke manje uthi ujudge uthi angisho izihloko zokubangisana seyifakiwe kanye ama-heads asefakiwe njalo kanti kuzomela ukuthi omnye nomunye ozokhulumisana nenkantolo akhulumisane nenkantolo eloku ekhumbula ukuthi ama-heads esefakiwe kakhulukazi ke futhi mayikhulumisana ke nenkantolo ebekhulumisana nenkantolo mhlambe uma ngabe kukhona okuthize okushiyeke emuva uma kufakwa le ihloko zokuphikisana ngaleyo ndlela mhlambe izihamba kahle.
My lord, as far as we are concerned, we'll take the court through our heads. We've made some additions. As far as reference to case law is concerned, we'll only refer to the relevant portions.
sizocela ukuthi sikwazi ke ukuthi siphaneke ngesithombe sama-heads wethu.
My lord, our
are
heads
you
are-
going to be repeating what you have already
No,
submitted?
no, I'm not going to repeat.
Alright, okay.
Yes.
Cha angizophinda lokho esengilobile okanye engibhale phansi kuma-heads.
My lord, our heads of argument are structured as follows. Under introduction, we set out the course of this matter, the objection that has been conveyed by the witness to the state, as well as the ground for such objection. And as I've already indicated, my lord, on Monday, we addressed the court on these grounds, and we are not going to repeat them as we've just mentioned, my lord. Suffice to mention that the matter is partly heard, and that the state is due to lose the evidence of witness number 1 on the list of witnesses.
Manje ke thina ke ngendlela ihloko zethu zingakhona ukuthi ke sizokwazi ukukhulumisana nenkantolo. Okokuqala sikhuluma ke nge-introduction okanye ke zama ke ukuthula la enkantolo ukuthi siphetheni okanye siqukethe ini. Okokuqala imbangela ekhona nje kuleli cala. Okwesibili inkinga ufakazi abenayo mayelana nokuthi ke icala liqhutshwe okanye lihanjiswe ngendlela ejwayelekile njengoba beloko liqhubeka kwabanye ofakazi. Kanti ke kukhona ke nezathu ezenza ukuthi ke kube nenkinga yokuqhubeka ngendlela ke efanele okanye ejwayelekile. Kanti go Monday inkantolo ikwazileke ukuthi ithu ukuhlala kwaseke kuba nendlela yokuthi umshushisi akhulumisane nayo inkantolo mayelana ke nalenkinga esikhona okanye lenselelo esikhona. Engakusho nje ukuthi le cala ke kuyiqala lokuliqhubeka aliqali nje ukuthi liqhubula enkantolo namhlanje okanye ngomsombuluko.
The issue therefore arises in the course of an ongoing trial.
Kanti ke lento lena ke iqhamuka njena ke iqala lokuliyaqulwa sengisho lenselelo ebe khona ngomvulo iba khona nje iqala lokuliyaqulwa okanye liyaqhubeka.
Can I interrupt you? Sorry for that. I'm checking how far we will go at this rate, because there is this approach, there is the other approach where Advocate Baloyi will cover a few paragraphs and then we have an interpretation, because the way it's going, it will take overly long. But I don't want to do it if it will not benefit the accused.
I don't intend going over the argument I presented. It's all in the heads of argument, together with the citations I made when I last appeared and argued before you on Monday, together with the additional quotes I referred to. I have 1 or 2 points to make, as well as 1 or 2 responses to my learned friend arguing for the state. So
Yeah,
I won't be more than 15 minutes.
Mr. Rosengarten, all I'm asking is whether interpretation should be sentence by sentence.
My Lord, our view is that it need not be sentence by sentence.
Yeah.
As the purposes, my Lord, that was our view that case citations and quotes should not be interpreted, my Lord. I think that's the view from the left here and the right, at least to this point, my Lord. As the court, please.
I think it is even not necessary to interpret what has been argued here. We'll definitely endeavor to explain it to our clients in the interest of time. Thank you very much.
Thank you, my lord. I think I can do the interpretation. I can do the interpretation to my client later on.
Okay.
My lord, we also can dispense with interpretation during these arguments. I will interpret for my client.
Okay. There you are.
I wish also to interrupt the court, my lord. I've just been asked by Mr. Tefo to report that he is sitting here in court as a watching brief, my lord, as the court pleases.
I don't know.
My request to my learned colleague has been just to introduce me, then I will stand up and give the reason why I'm here. That is what I requested from her.
No, she said you are a watching brief. I think we should leave it at that because we are busy with the process. I've been told by Advocate Mshololo that
Yes.
you said I should know that you are here as a watching brief.
Yes.
And I think that does it.
She didn't put it in a correct way, in the right context.
No, please.
So I will definitely put it in the correct context.
Mr. Tefo,
As a watching brief, I've been
the
saying
other day outside here, we started late because I was explaining to you that these accused persons have paid these representatives who are here to represent them in this case. And whatever time we spend here, it is at their expense. Now you are watching. That's what you are telling me. I'm asking you to stay put and watch that brief and allow the representatives of the accused to play their roles. Now it is the opportunity from Advocate Baloyi to address me. Now what you want to do now is coming in between, and it is disturbing these proceedings. Sit down and watch. I am not saying I'm allowing you to sit down and watch the brief, or I'm disallowing you, but I have been told and I have noted it.
Your Lordship, like I said, let me put in the right context.
No.
I'm not here to sit and watch.
You are not going to address me.
I've been given instructions, several instructions by Sifiso Maiwa, the brother of the deceased. I've been given the instructions.
You are disturbing.
by Orlando Pirates
You are
Management.
disturbing court. Please sit down, or I will order that you be taken out. You are disturbing us.
If you feel like that, Your Lordship, you can do that. But you must know that you are depriving the right people who are affected by this.
Yes.
This witness is a witness of the great interest to Sifiso Maiwa, to
Mr.
Orlando Pirates,
Mr.
to Orlando
Tefo,
Pirates supporter staff.
Mr. Tefo, sit down and allow Advocate Baloyi to continue with what is of interest in this case, which is what I want to hear. There's a ruling for me to make, and time is of essence. I'm saying sit down and allow Advocate Baloyi. This is an interruption, and it is rude if you ask me. It is a rude interruption which is unnecessary for our purposes. You are not the only watching brief that was spoken about in this case. There's never been a watching brief here who has interrupted proceedings.
I'm not just watching.
And watching briefs don't address court. On whose behalf are you addressing me?
I am not just watching brief. I've got instructions.
Mr. Tefo, please
So
sit down. If you don't sit down, if you address me wasting time again, I request the court orderlies and whoever is responsible in this court to make sure that you are taken out.
I'm not intending to interrupt this court.
Sit down.
Your Lordship.
Sit down,
What I'm saying
Advocate
is that just be
Mr.
known that
Tefo.
I'm here to bring the submission later. In relation
I
to
told you that I've heard that.
Thank you.
Why must you say it 100 times?
Thank you, Lordship.
And when you submit whatever, it will be for me to decide whether I take it.
Definitely.
But I will decide that that has not happened yet.
It will start from there.
Advocate Baloyi.
As the court pleases, my lord, we have mentioned that our heads of argument are structured as follows. We have already mentioned the introductory part. We then deal with the court process as the second topic. The third topic is devoted to the test that ought to be applied in this matter. And lastly, we deal with the approach of the courts in similar matter. My lord, just to restate the position until now, the proceedings have hitherto been broadcast live, but only with live audio transmission of the evidence of the last two state witnesses. In other words, there were no visuals. We've indicated, my lord, that witness number 1 on the list of witnesses is opposed to the live broadcast of evidence, be it visual and audio. And we've indicated, my lord, that she has no objection to the journalist sitting in court. Away from the world of glitz and glamour, she is but a witness with vulnerabilities and anxieties for the witness stand. Being a victim of crime is traumatizing. My lord, we have seen the two previous witnesses breaking down at times. Now, why should this witness be castigated if all that she's asking for is this? She wants to come and relate her story of how she saw the commission of a crime, but she's asking to do so in an atmosphere that is less intrusive. We can mention, my lord, that there is a service charter for victims of crime that was spearheaded by the Department of Justice and other relevant role players, which, if fully implemented, my lord, accords victims of crime certain rights and also incorporates minimum standards on services for all victims of crime, irrespective of their social standing. Role players in the criminal justice must ensure that these rights are observed, such as the right to be treated with fairness and with respect for dignity and privacy, as well as the right to protection and so on. We mentioned on Monday, my lord, that the witness has pointed out to the practice of public scrutiny of evidence of witnesses, comparing the evidence of witnesses who have already testified and criticizing such evidence while the witness is still testifying. We mention in our heads, my lord, that this is an exercise that the court will eventually have to perform in evaluating the evidence of witnesses at the conclusion of the case. And in our heads, my lord, we refer to the case of MultiChoice and others versus NPA in the matter of State versus Oscar Pistorius. We've given the citation. And we just want to refer the court to the relevant paragraph 28, where the court remarks as follows: that it has come to the attention of the court that there are media houses that intend to establish a 24-hour channel dedicated to the trial only, and that the panels of legal experts and retired judges may be assembled to discuss and analyze the proceedings as they unfold.
So, I missed the number of the paragraph the council is referring to.
It's page 602, my lord. Because of this intention, it behoves me to reiterate that there's only one court that will have the duty to analyze and pass judgment in this matter. The so-called trial by media inclinations cannot be in the interest of justice as required in this matter, and have the potential to seriously undermine the court proceedings that will soon start, as well as the administration of justice. We submit, my lord, that a witness should be given a choice of whether they prefer testifying in the normal way or in front of cameras. We again, in our haste, refer to what will, for sake of brevity, refer to as the Oscar Pistorius case. Page 603 at paragraph 4.5, where the court made the following order: the portions of the trial that may be recorded and broadcast the evidence of all other witnesses for the state, unless, and this is the point that you want to buttress, my lord, unless such a witness does not consent to such recording, that no such recording and broadcasting can take place. My lord, in arguing for the justification of the live broadcast of the proceedings, reference was made to the educational value of showing or carrying the proceedings live. But my lord, there are a lot of cases that take place on daily basis in the lower courts, in the higher court, that are not being televised. My lord, cases involving Joe and soap in far-flung areas. Why is there only a focus on cases that are of a high-profile nature?
Is it not because then there is a greater sense of public interest around the case, that there is there are more people interested, and I think the case in point is a perfect example.
Yes.
That it doesn't reside within the periphery of the family interest or even the interest of those who were around when the offense was committed. Scenarios, I doubt whether it will be the best approach.
Indeed, my lord, that is the point that you want to make in the following two instances. Firstly, are there other interests that are being pursued except for the educational value of such proceedings? And secondly, my lord, are they the only cases that have got educational value? What about a case of a poor person in a far-flung area? Isn't there educational value in such cases? All I'm saying, my lord,
is it us? Is it you and me?
Yes.
Is it those of us who are here who can decide what should be regarded, what the general public should regard as having educational value?
Yes.
I think its value not so much as looked at by me and you to the exclusion of everyone else.
Yes. All I'm saying, my lord, is that this aspect of educational value should not be stretched beyond its elastic limits. There appear to be other considerations. I can only take the point as far as that, my lord.
Yes.
We've referred to this case of Pistorius, where the court held at paragraph 4.5 that the portions of the trial that may be recorded and broadcast the evidence of all other witnesses for the state.
You are now on page,
Yes.
on paragraph?
I'm on page 4, my lord. On page 4, paragraph 1.8. My paragraphs have changed slightly, but it's on page 4. We've mentioned that it is important, my lord, that the witness should, the judgment of in the Oscar Pistorius matter properly interpreted implies that the witness should consent to the live broadcast of that witness evidence. Then, my lord, we deal with court process. We mentioned the fact that counsel on behalf of the media has joined issue with the fact that the objection was argued on paper. In other words, it was raised from the bar as opposed to bringing it by way of a formal application, by way of notice of motion, accompanied by a founding affidavit. My lord, we submit that it is a matter of substance and not even longer to finalize. My lord, we mentioned that there's still a number of witnesses who are still due to testify, and that some of them are likely to request for the exclusion of the live coverage of the evidence, even from police officers who are witnesses. We make the submission with respect, my lord, that it is untenable to suggest that all such objection be brought by way of notice of motion. And I've seen the heads on behalf of media houses, and this very same aspect is repeated there. We make the point, my lord, that such objections can also not be foreseen, as a witness can change his or her mind anytime about testifying in front of cameras, and therefore that the objection must be dealt with as they arise on a witness-to-witness basis. And counsel argued that this is something that should have been dealt with at pit trial. My lord, we submit with respect that because I think counsel for accused number 5, we mentioned, my lord, that that is not something that can be foreseen. It can arise, as in this instance, on the eve of the evidence or the witness giving evidence. And at paragraph on page 5, we mentioned that there was an application that was brought by the SWAL counsel for accused number 1 and 4 for the exclusion of parts of the media and 1010 producers, which was also argued on paper. We submit, my lord, that in light of the fact that this is going to be a long and protracted trial, the court is entitled to devise quicker and convenient way of dealing with all the issues that arise during the trial. This court has got inherent powers to regulate its own process, as envisaged in section 173 of the Constitution. And we refer to the Van Breda case, my lord, that was extensively referred to on Monday, where the court held as follows: the trial process, already time-consuming and expensive, must not be allowed to become further unnecessarily protracted. Then, my lord, next we deal with the tests to be applied. At issue in this matter, it's a clear contestation of rights. The nub of this matter is about the balancing of the right to privacy of witness number one against the right of freedom of expression when considering the exercise of the media freedom of expression in the courtroom and the right to a fair trial. All come to the fore. We submit, my Lord, that it must therefore be ensured that the interests of justice are upheld. And in the Oscar Pistorius matter, this concept of interest of justice, the court held at paragraph 17 that it does not only relate to an accused person, right to a fair trial, but also to the prosecution's right to the same right, as well as all other interested persons' rights in the same proceedings. And in that case, reference is made to the Constitutional Court case of State versus Dlamini. We give the citation there, wherein the court said this concept of what is a fair trial denotes in broad a value judgment of what will be fair and just to all concerned. And the court went further to hold on that the right to a fair trial suggests that freedom of expression rights to which the applicants lay claim should be attenuated, and that the open justice principle should necessarily suffer the same fate. It is inevitable that in the exercise of the Balancing Act, as well as the powers found in Section 173, the rights at issue in this matter will be limited in one way or the other. The approach to ensuring that each right find expression and the extent thereof was articulated in the media television case that my learned friend on Mr. Rosengarten on behalf of media houses referred to on Monday. We give the citation and we refer, my Lord, to paragraph 9 thereof, where the court held as follows: where here constitutional rights themselves have the potential to be mutually limiting, in that the full enjoyment of one necessarily curtails the full enjoyment of another and vice versa, a court must necessarily reconcile them. They cannot be reconciled by purporting to weigh the value of one right against the value of the other, and then preferring the right that is considered to be more valued and jettisoning the other, because all protected rights have equal value. They are rather to be reconciled by recognizing a limitation upon the exercise of one right to the extent that it is necessary to do so in order to accommodate the exercise of the other, by recognizing an appropriate limitation upon the exercise of both rights. In paragraph 3.3, my Lord, we have already referred to the Oscar Pistorius case, wherein at paragraph 71, the court held that it remains the duty of the trial court to examine with care each application that courts should exercise a proper discretion in such cases by balancing the degree of risk involved in allowing the cameras into the courtroom against the degree of risk that a fair trial might not ensue. Paragraph 3.4, my lord, we refer to what the court held as a tension between the right for freedom of expression and the open justice principle on the one hand, and the rights to a fair trial, and that those rights should, as far as possible, be harmonized with one another. My learned friend on Monday referred to the need for the court to determine whether there is demonstrable risk that a certain prejudice will occur, and that mere conjecture and speculation that prejudice might not occur ought not to be enough. We refer to paragraph 17, where the court held that the right to a public hearing does not automatically mean that trials must necessarily be broadcast live in all circumstances. And my lord, as we've indicated that there are many trials taking place in the country, it is by way of exception that you have a trial being televised, as in the current situation. It is therefore our submission, my lord, that we need to tread very carefully if a witness says they are uncomfortable to testify in front of cameras. And my lord, this brings into sharp focus the role of witnesses in courts. When giving evidence, witnesses perform a public duty. A witness performs a civic duty when he or she comes to court to testify about the commission of a crime. Witnesses help the courts to resolve the disputes that serve before them. And we submit, my lord, that witnesses therefore need to be accorded courtesy and respect, and that their reasonable needs need to be accommodated. Others witnesses will be deterred from coming to court to testify. And we've already mentioned, my lord, that as a starting point, no witness should be forced to testify in front of a camera. If a witness says they are uncomfortable to testify in front of a camera, we submit, my lord, that alternative ways should be explored. We submit with respect, my lord, that the right of the public to be informed of court proceedings can never trump the right of a witness to testify in a way that is comfortable to him or her.
By alternative means, what are you referring to?
My lord, for instance, we suggested to Mr. Rosengarten that the evidence of this witness can be recorded and then shown at the later stage when the witness has already finished testifying.
Is that not what Mr. Rosengarten spoke about?
He was only referring to the visuals, not to the sound recording.
Okay.
My understanding is that he's opposed to the to the fact that the witness evidence be recorded, albeit only via sound, and then shown at the later stage. I think he went on to argue that during current affairs program, then the visuals can be shown. And this is what he's also asking for in his heads, that the court should go further and order, contrary to what has been the practice now, that even visuals should be recorded to be flighted at the later stage. We submit, my lord, that there's no reason to interfere with the current practice where the proceedings are shown live, but if a witness says, for security purposes, as with the past two witnesses, if they say, please, I don't want my face to be shown, that there's only sound recording. We submit, my lord, that there's no reason to disturb the current arrangements. My lord,
And are you saying that the visuals emanating from that process should remain out of reach to posterity? That it doesn't matter how long after the conclusion of the trial, that they remain forbidden from being broadcasted?
Well, my lord, after the conclusion of this case, there shouldn't be any objection to to that material that has been archived to be used for educational purposes. My lord, we point out that the live broadcast of court proceedings has also its own disadvantages. It is not as if, my lord, it's a panacea to witnesses who cannot come to court. It's not a panacea to open justice. The live broadcast of proceedings have got this distinct disadvantage, my lord, in that witnesses who might still testify might watch how witnesses before them testify, how they are treated. We therefore submit, my lord, that it is not a panacea to informing the public of court proceedings. We, as I've already mentioned, that recording the evidence and showing it and showing the evidence after the conclusion of the case is another way of informing the public of court proceedings. And this will in fact ensure that no witness who's yet to testify can watch the evidence of witnesses who testify before them or become apprehensive as to how such witnesses are treated. In the Van Breda case, at paragraph 73, it was even suggested that in other instances, broadcast of testimony of an objecting witness could be delayed until after the trial is over. This is what we have just submitted. My lord, we submit that witness number one harbors a reasonable apprehension that harm might befall her. It cannot be said that such harm must first eventuate to demonstrate that there's real risk of harm occurring. We submit, my lord, that it is about a reasonable belief held by the witness. And we mention here, my lord, that if a witness is expected to testify about such belief or submit an affidavit as suggested by counsel for the various media houses, the court might be called upon to make a finding about the credibility of such a witness before the witness has even testified. We therefore submit, my lord, that arguing the matter on paper is the correct approach. Then the fourth topic, my lord, we deal with the approach of the courts. We have already mentioned that in the Pistorius case, the court held that or implied that the witness must first consent to the live coverage of his or her evidence. We've already referred to the court's power to regulate its own process. We're not going to repeat it. And perhaps lastly, my lord, on I think the rest of the paragraphs have already been dealt with on Monday, pages 9, 10. We have already dealt with that, my lord. We're not going to repeat it. Page 11, that has already been dealt with. Then the last aspect, my lord, it's the point that was raised by counsel for accused number 3 and as well as counsel for the various media houses. But in particular, my lord, counsel for accused number 3 argued that the first witness has already participated in the making of a documentary which was flighted on Netflix, which depicts events that led to the death of the deceased. We had a discussion this morning, my lord, with counsel for the media houses, and we are agreed, my lord, that first witness did not participate in the making of that documentary. And they would know better as he represents the media houses. And we also have an affidavit to that effect from this witness that she did not participate. We, other counsel indicated that they will object to the handing of the affidavit. We therefore leave it at that, my lord, that counsel for media houses and the state are agreed that she did not participate in the making of the documentary. The only other aspect that remains is her participation in the interview by ENCA. Here, my lord, we submit that it needs to be mentioned that ENCA was in breach of the sub judice rule in so doing, as this case was pending and the witness was yet to testify. We also submit, my lord, that an interview is also controlled. A set of questions are sent in advance and can thus never be compared, my lord, to testifying in court. We therefore submit, my lord, that the objection of the witness to testify before cameras should be upheld. This is as far as we can take our argument, my lord. I don't know if there are any other aspects.
Just before we adjourn for tea, the one short question I have, there was reference on Monday to, let me not say reference, there was an allegation on Monday made by one of the representatives that even as we were debating this aspect of the broadcasting of proceedings in this case, the applicant was active in the social media, communicating, as it was alleged, far and wide about her take to this case. I didn't get into asking the details of what was being alleged, but the long and the short of it was that she was, the applicant was communicating on social media and therefore placing herself out there for the very criticism that she now sounds to be apprehensive about.
Yeah, well, my lord, regarding social media, I think debates that occur in the platform, I don't know whether those debates can be put before this court. We know what the nature of social media is, but
No.
during the
We're not talking about social media, yes, in the wide sense.
Yes.
We're talking about social media to the extent that the debate is triggered by the applicant herself.
Yes.
I think that will be different from where
Yes.
somebody may be watching as they may be now, and they decide to run a debate. Some I don't know. I'm not active in that
Yes.
in that periphery, and whatever happens there, there may be talks going up and down around it, because they are watching and they are observing. They have opinions, they have ideas, they have objections, which are irrelevant for our purposes. But here they were saying, here is an applicant who is represented in court by the state, who is saying, one of the reasons why I do not want the beaming of visuals and the broadcasting of audio proceedings in this case is because it will bring me into focus before the members of society, and it will render me liable for criticism and scrutiny. That it sounds like a contradiction, in that the very same person doesn't want society to be at this stage debating about what she did say or do or did not say. But then at the same time, that person is placing herself out into that very field where, without choice, somebody will respond, react, object, or whatever will happen.
As a court, please, perhaps we can take the short adjournment. We'll then deal with this issue when we resume.
Rise.